All right, let's move on to this story then. The Supreme Court of Appeal has dismissed the Ingonyama Trust Boards application for leave to appeal a ruling that they acted unlawfully by initiating residential leases with people who were living on Zulu customary land with permission for generations. Legal Resources Centre attorney Saadiyah Kadwa joins me now to explain what this means. Saadiyah, good evening and thank you for your time. Let's go back into the human story here of the people who have been living on the land, the residents who'd been there for generations. What did the threat of this court action and the proposed rental mean for them?
Good evening. So the human story is quite a serious problem that people had faced because the implementation of leases imposed a serious threat to Zulu people living on Ingonyama Trust lands security of tenure. What this means was that people had rights in terms of customary law, they had rights in terms of permissions to occupy, and these rights secured them rights in perpetuity to the land. However, once the Ingonyama Trust stepped in and implemented their system of leases, it sort of put these rights in jeopardy because a lease is a much more insecure right than, for example, a permission to occupy or rights in terms of informal or customary law. So, in effect, what that meant is that once those leases were implemented, if people did not keep up with the rental payment that comes along with leases, then they could be evicted off the land. And this was not a fear or something that people suffered when they had rights in terms of the informal rights or in terms of permission to occupy.
Saadiyah, just tell us why the Ingonyama Trust wanted to go the route of rentals and not some of the traditional routes that you just mentioned, such as the permission to occupy.
Well, that would be me answering for the Ingonyama Trust. However, what we can say and what we've alluded to in the what we've actually put forward in our papers was that the Ingonyama Trust and the Ingonyama Trust Board benefited financially from the lease system. The figures are not in front of me, but in a single year, about 90 million was collected from the revenues that came from leases. However, those were not the figures when, for example, people were living in terms of customary law or permissions to occupy, which had nominal rents. So for us, it has a lot to do with the Ingonyama Trust and the Ingonyama Trust Board benefiting of people who ultimately should be the owners on that land.
Well, how are those who are directly affected or have been directly affected by the prospect of this development reacting to the news?
Well, so there are the judgment that has the order that has been granted. What it does is we have to go a little bit back into the actual order and what it means and what has actually been dismissed, because there were two aspects to this order. In May of this year, the Ingonyama Trust and the Ingonyama Trust Board appealed to the provincial division of the High Court, meaning the Pietermaritzburg High Court. Firstly, they appealed the merits of the matter, so the actual order that was granted in June of 2011. And they also added a recusal point. That it's so termed the recusal point.
Yeah.
What the recusal point sort of mentioned was that the late Judge Mguni and Acting Judge President Madondo own land on Ingonyama Trust land, and they wanted to, so the Ingonyama Trust effectively wanted to admit new evidence and submit the point that they should have recused themselves from the matter, and the matter should actually be heard afresh at the KZN High Court.
Yeah.
That was dismissed by...
Yeah, because they were accusing the judges then of bias in this matter. As you say, that's a piece that has been dismissed. What were some of the arguments that you brought, that ensured it didn't pass muster?
So the arguments that were brought was that in order to admit new evidence, one has to pass a very stringent test because the potential of prejudice to clients is very high. In this case, what that would have meant for our clients is that we had to start all again, start afresh from the beginning. In the Pietermaritzburg High Court, and that would have set back our clients years because this matter was initially instituted in 2018, and the order was granted, the first order was granted in 2021 of June. So it's been a long time, and our clients would then have to start that procedure afresh. So there was a very high possibility of prejudice that would have visited our clients were this recusal point have been accepted. And the LRC, therefore, and our clients also welcome this dismissal of the recusal point because it means that the matter can now move forward.
But it wasn't done, as far as I understand, and correct me if I'm wrong, just around, the impact to the claimants or to the petitioners to the court, but also that on merit, the argument itself wasn't enough to dismiss the decision that those judges made.
That's correct. So the judgment on merits is actually still with the Supreme Court of Appeal. So how it works is that in the High Court, in May of 2021, the Ingonyama Trust appealed or sought leave to appeal to the Supreme Court of Appeal. And on the merits, meaning the judgment that was granted in 2021 of June, they have been granted the leave to appeal. So the merits judgment still is yet to be heard by the Supreme Court of Appeal. So there are distinct differences. Well, there's a split between the recusal point and the merits is yet to be heard by the Supreme Court of Appeal.
So given that that's the case, it would seem that the matter is still unresolved insofar as the fate of those who are still living on the land, because that matter is yet to be decided. Have you heard from your counterparts in the case as to, well, maybe just ask from your perspective what the next steps are likely to be?
Yes, that's correct. So the next step would mean that the SCA, the Supreme Court of Appeal now, would have to consider the appeal matter brought by the Ingonyama Trust and the Ingonyama Trust Board. So there's a sort of role reversal where the Ingonyama Trust is now the appellant, meaning they have brought the case before the Supreme Court of Appeal, and our clients being the Council for the Advancement of the South African Constitution, the Rural Women's Movement, and our 7 individual clients who were leaseholders will now be the respondents in the matter. And that is yet to come.
Just a quick final point, because it's quite an important issue, as you say, Saadiyah. If this is allowed to happen here and it changes the formulation around how people who've lived on land for generations, in a clan, in a community, are able to have access to that land, it might impact what happens in other similar environments across the country. Would you say in that regard, it's quite important, especially with regard to precedent?
It is important with regard to precedent because it sort of goes back to the true meaning of the customary law, because that's what we argue, is that the Ingonyama Trust is the sort of administrator of the land, and our clients are the true and beneficial owners of the land, and they should be allowed to live on the land. So it does have importance, especially for women as well, because one of the main salient issues that was argued in this case was that women were excluded from even entering into these leases, even though the leases are not what we want for our clients. But it was a problem even for our clients who couldn't access leases either. They would have had to have brought a partner to co-sign the lease with them. So it also exposed a lot of the patriarchy and the underlying issues that rural women face. Well,
thank you so much, Saadiyah, also just for clarifying the split in those issues and the work and the journey, the legal journey ahead in the resolution of the matter. Appreciate you tonight. Legal Resources Centre attorney Saadiyah Kadwa.